everyone, and welcome to this, the fifth and final webinar in our series Resolving Rural Disputes. My name is Hamish Lean. I'm a partner in the firm's rural business team based in our Aberdeen office. I have good experience of dealing with agricultural subsidy appeals, including a number of successful appeals in the Scottish Land Court. And what I'll be speaking to you today about is the appeal procedure in relation to agricultural subsidy decisions. What I hope you will come away from this webinar with is a basic understanding of how to go about making an appeal, what the rules and time limits are in respect of the appeal process, and what the role of the Scottish Land Court is in relation to the appeal process itself. I'd like to begin, however, with a backward glance at the historical rules which did apply to the appeal process, which will help understanding the current process. Previously, the rules were contained in the Rural Payments Appeals Scotland Regulations 2009 as amended by regulations in 2012. These regulations themselves were simply the latest incarnation of a number of regulations in relation to the appeal process, which had been in existence really since the start of the IACS scheme way back in 1994. In any event, the previous regulations had been severely criticised by the industry. The reason for this was that they provided for a three-stage appeal process. The first stage was an internal appeal dealt with by the department, and an appeal lay from that decision to an independent appeals panel, which was made up of 2 lay members and a member of the department. Now, the independent appeals panel could and often did overturn the department's own decision at the first stage of the appeal. But one of the problems about that process was that Scottish ministers could then overturn the independent appeal panel's decision. And accordingly, although there was an impression of independence in relation to the appeals process because of the existence of the independent appeals panel, that impression was in fact false, because Scottish ministers retained the power and often did overturn the decisions of the independent appeals panel. The other major problem about the previous procedure was that it had no rules about time limits which any of the parties had to comply with, and it was often the case that a subsidy appeal became lost in the bureaucracy of the department and would often take years to go through the whole process. If the appeal was turned down either by the Independent Appeals Committee or by the Scottish ministers, then the appellant had a right of appeal to the Scottish Land Court. The current law is contained within the Rural Payments Appeals Scotland Regulations 2015, and it has radically streamlined the appeal process itself and imposed a number of time limits in respect of the steps which the parties must take for the appeal. First of all, the regulations apply to appeals against relevant decisions. What is a relevant decision, I hear you ask? Relevant decisions are decisions in relation to any of the schemes which are detailed in the schedule attached to the regulation. Now, the schedule is really wide-ranging, but essentially it includes decisions to postpone, refuse, reduce or recover in whole or in part any payment under an IACS scheme, and the schedule is wide-ranging enough to include LFAS decisions, cross-compliance breaches, Pillar 2 support scheme breaches, and a wide range of associated regulations and schemes under CAP. Where a claimant does wish to make an appeal against a relevant decision, they must apply for review of that decision not later than 60 days following the date of the Department's decision letter. Normally, the decision letter will inform the claimant that there is a 60-day time limit within which to apply for a review. There are certain requirements in relation to the application for review. First of all, it's got to be in writing. It must specify the name and address of the person making the appeal and, where relevant, the details of their representative. It must detail the scheme in relation to which the review is sought and, in relation to an IAC scheme, the calendar year to which the new or relevant decision referred. It must also set out what the relevant decision actually is and the date that that decision was made, and the appellant must also set out what change they seek to make to the relevant decision and the reasons why it should be changed. On receipt of a review application, the Scottish Ministers must then review the relevant decision and must provide the claimant with an opportunity of being heard at a review meeting. And that meeting must be held within 60 days of receipt of the application. The Scottish Ministers must intimate the date of the review meeting to the claimant in writing, and the claimant has an opportunity, either themselves or via a representative, to make representations to the Scottish Ministers about the appeal. The review meeting can be conducted in person or, with the agreement of the claimant, by use of telephone or video conferencing facilities, or such other arrangements by which the claimant is able to participate in the meeting. Following the review meeting, the Scottish Ministers can, in respect of their original decision, confirm that decision, they can amend it, or they can revoke it in its entirety and substitute a new decision. The Scottish Ministers must issue their decision in a written report, and the written report must set out the decision of the Scottish Ministers following the review, the requirements of the scheme in respect of which the claim was made, where that's appropriate, the facts relied upon by the Scottish Ministers as showing that the requirements were not met, and, where appropriate, the matters in fact or law which are understood to remain in dispute. The written report must be issued within 60 days of the date of the review hearing. And where Scottish Ministers turn down the appeal, the appellant has a right to make an appeal to the Scottish Land Court on a question of fact or law, and I'll come back to the significance of that in due course. But the appellant has a period of 60 days from the date of the review report to make that appeal. Hence the 60 days plus 60 days plus 60 days time limits set out on the screen. The appellant has 60 days from the date of a decision to make an appeal. The Department has 60 days from the date of receipt of the appeal to hold a review hearing, and the Department has 60 days from the date of the review hearing to issue a decision, and the appellant has 60 days from the date of the decision to make an appeal to the Scottish Land Court. Once again, if the appellant fails to comply with the time limit, that's the end of the appeal. But if Scottish Ministers fail to comply with the time limit, the consequences for them are much less severe. What that does is give the right to the appellant of making an appeal direct to the Scottish Land Court. So the consequences of failure depend actually on who you are, but at least the benefit of the new procedure is that the appellant has an opportunity to go direct to the Land Court and, as it were, force the pace of the appeal. Which takes us to the Scottish Land Court. I've put up on the slide a picture of the court itself. The Scottish Land Court is a court of law, but it does deal with matters with a relatively light and informal touch, and is not in and of itself an intimidating place. Something to copy and paste into your browser as a favourite is the Land Court's website, www.scottish-land-court.org.uk. The website has a wealth of information in relation to the operation of the court. It includes its detailed procedural rules, about which I'll say something in a moment. It contains full details of important previous decisions of the court made since 2007, and it sets out the application forms which must be used when making an application to the court, and it has a specific form to be used in relation to an appeal under the 2015 regulations. So if someone is making an appeal to the Scottish Land Court, they must specify in the application what the grounds of appeal are, what finding of the Scottish ministers is challenged, any facts the claimant seeks to rely on, the arguments to be advanced in support of the appeal, and brief details of the legislative provisions or judicial authorities to be referred to in the appeal itself. The appeal must also be accompanied by the decision letter, the application for review, and the written report. Where no written report has been issued within the time limit for doing so, the appeal must be accompanied by the decision letter, the application for review, and evidence of the date of the review meeting intimated to the claimant. Although this might appear to be quite a daunting task, where Scottish ministers have issued a written report, it will set out all of the facts that the Scottish ministers are relying upon, the arguments that they are advancing in support of refusing the appeal, and it will provide details of the legislative provisions that they are relying upon. And accordingly, much of the information which the appellant needs to put together the appeal application will appear in the written decision by the Scottish ministers. The Land Court has power to order the Scottish ministers to submit a written report, and accordingly it would be possible in an appeal to ask for an order from the court that the Scottish ministers make that written report, upon which could be bulked up the appeal itself. Land Court also has power to grant leave to the Scottish ministers to amend their report, and it can also relieve a claimant of any of the formal obligations in relation to the appeal application. It's often the case that party litigants will conduct their own appeals before the court. The court, whilst retaining its complete impartiality, will try to help a party litigant in those circumstances comply with the procedural requirements at least, but professional representatives will get much less slack from the court. The court can also ask for such additional information or submissions to be submitted by the parties to the appeal as the court thinks fit. In determining the appeal, the court has the following powers. It can confirm the decision of the Scottish ministers, in which case the appeal has been lost. It can amend or alter the decision in any respect which it considers appropriate. It can substitute for the minister's decision any decision which the court considers appropriate, and it can refer the matter back to the Scottish ministers to decide the matter of new. And any determination of the court is binding upon the Scottish ministers and the appellant. An appeal does lie from the Scottish Land Court, however, to the Court of Session, but only on a question of law. So what does the court do? What I mean by that is, how does the court actually practically deal with an appeal itself? The first point to make is that an appeal to the Scottish Land Court is on a question of fact and law. What this means is that the court is able to hear evidence in the case and substitute its own findings in fact for those made by the Scottish ministers at the first stage of the appeal. The court's not bound by the Scottish ministers' own findings at the earlier appeal stage, the court, in essence, has the power to hear the whole case anew and make its own decision. The court can reach its decision on the appeal in a number of ways. Firstly, if the parties agree and the point at stake is a relatively simple one, it can decide the appeal on written submissions only. Secondly, if what is at issue is the correct interpretation of a particular rule, it can decide matters after hearing the parties or their legal representatives in a formal legal debate. Finally, if the facts of the matter are disputed, the court will hold a formal hearing on evidence, with witnesses being called and giving evidence under oath. I'd mentioned previously that the court's website has a section detailing all of its decisions in important cases since 2007. I'm going to look at a number of cases where lessons can be drawn about the conduct of the appeal. For those interested in reading those cases, they're all available on the Land Court's own website. That the court can find for or against an appellant based on the evidence that they present and whether or not they are believed is demonstrated in the contrasting cases of Innes v. the Scottish Ministers in 2013 and Morrison v. the Scottish Ministers in 2017. Both appear on the face of things to be broadly similar in their facts. In Innes, this was an appeal against a decision of the Scottish Ministers arising out of an apparent failure to notify the deaths of 28 cattle on a holding. The appellant claimed in evidence that passports had been posted to the British Cattle Movement Society on each occasion, and that those passports had gone missing either in the post or at the society itself. However, the Land Court held that there was adequate evidence that the passports had not, in fact, arrived at the society. The missing numbers were too high to be accounted for by errors of the Post Office, particularly when it had to be assumed that all had been properly addressed. The applicant's description of the system in place about posting passports in the written appeal application differed from the version given by witnesses under oath in court, and at the end of the day, the Land Court simply disbelieved that the appellant had posted the passports in question, and the appeal was turned down. In Morrison, the decision being appealed against was an alleged failure to notify a single movement of sheep between one holding and another, and a penalty had been imposed under the LFAS scheme. In that case, the court accepted the applicant's evidence of a well-understood system of posting movement documents, and the fact that this was a single instance of a missing document, the fact that the appellant had the duplicate and triplicate copies of the movement document which was missing, led the court to take the view that it had no reason to doubt that the document had been posted, and accordingly the appeal was upheld. There have been a number of appeals dealt with by the Scottish Land Court where the court has pointed out that Scottish ministers should not rely on their own guidelines in the interpretation of the relevant regulations, both at domestic and European level. It's often the case that the guidelines are incorrect or incomplete. Quite often, Scottish ministers construe their own guidelines in a way that is more onerous than the regulations that they are commenting upon justify. It's always the case that an appellant should refer to the underlying regulations rather than the Scottish minister's own guidelines when trying to determine whether or not a decision is correct or has been made in error. In the case of Morrison, Scottish ministers had argued that even if the movement document had been posted, the appellant was under an obligation to check with the Scottish Animal Movement Unit that the document had been safely received. The Land Court pointed out that there was absolutely nothing within the regulations, either at domestic or European level, that imposed this obligation on the appellant, and the appeal was upheld. Another example can be seen in the case of Nine Wells Limited v Scottish Ministers in 2011. This was a case to do with an alleged over-application of nitrate fertiliser in a nitrate vulnerable zone. The appellant argued that he had historic evidence of increased yields from neighbouring farms that justified the application rate, and that this was permitted by the regulations. The Scottish Ministers argued that the historic evidence of increased yields had to come from the farm on which the nitrate fertiliser was being applied. The appellant could not do that because they had very recently taken the farm over under their management. However, the court rejected the Scottish Minister's argument and upheld the appeal on the basis that the relevant regulations did not support the narrow interpretation that the Scottish Ministers were trying to place on them. I've set out what I consider to be a hierarchy of regulations when considering agricultural subsidy appeals. First place to start are the regulations at European level. The second place to look are the domestic regulations which implement the European regulations. Guidelines, of course, are not regulations at all and come a poor third place in that hierarchy. Guidelines, as the Scottish Land Court has pointed out on a number of occasions, simply represent the Scottish Minister's own understanding of the regulations. They're not a statement of law, and quite frequently, as the Scottish Land Court has found in a number of subsidy appeal cases, the guidance is wrong. On occasion, that's led to quite unfortunate consequences for appellants who have based their appeal on the fact that they've simply followed the Scottish Minister's own guidance. The Scottish Land Court has decided in a number of those cases that it doesn't matter what the guidelines say, the court is bound to implement the law, as in fact are Scottish Ministers. Reverting to my list of cases, just a wee word of warning for professional advisors in relation to Watt Taylor and Company Limited v Scottish Ministers, which was a case in 2013. In that case, the appellant argued before the court that the mistake in the relevant application form had been one that was made by his professional advisor and not him, and that therefore he should be excused the consequences of the error. The Scottish Land Court made short shrift of that argument, pointing out that if the appellant employed a professional representative, then they were stuck with the outcome. And I suspect what that then led to in due course was a claim for professional negligence against the professional advisor. So what I've been talking about up to now are the 2015 regulations in relation to subsidy appeals. It's important that if you get to the stage where you're making an appeal to the Scottish Land Court, that the Scottish Land Court has its own procedural rules which must be complied with in relation to the appeal. Those rules are contained in the Rules of the Scottish Land Court Order 2014, which once again is quite helpfully available on the Scottish Land Court's own website. The rules contain strict time limits with regard to lodging documents in advance of a hearing, intimating witnesses to the court and to the Scottish Ministers, intimating the statutory authorities and case law which are to be relied upon, and so on. Failure to understand and comply with those procedural rules might have the result that important evidence on your client's behalf cannot be laid before the court, and this may have a severely prejudicial effect on your client's prospects of success. Now, you may expect me to say this, of course, but I strongly recommend that you advise your clients to take legal advice from a suitably experienced practitioner if they're at the stage of contemplating an appeal to the Scottish Land Court. And of course, it's never too early to call your solicitor, especially given the strict time limits which are counting down in relation to the appeal process. Remember, 60 days. In respect of expenses, the Scottish Land Court follows the normal rule, which is that expenses will be awarded in favour of the successful party. Accordingly, if the appellant is successful and the decision of the Scottish Ministers is overturned, they can usually expect to have the expenses of the appeal awarded against Scottish Ministers. However, the opposite is also true, so that if the appellant is unsuccessful, the court will grant expenses in favour of the Scottish Ministers. Each case, of course, turns on its own facts and circumstances, but generally speaking, appellants will have to consider very carefully whether it is worthwhile running the risk of incurring expense in the court, weighed against the amount that they are likely to recover in a successful appeal. However, where the sums at stake are very large, appellants are often left with little choice other than to push ahead with the appeal. Finally, ladies and gentlemen, thank you for your attention, and simply to wrap up, one thing that appellants can have confidence about in the appeal process before the Scottish Land Court is that they will get a scrupulously fair hearing. The duty of the court is to apply the law to the facts that it finds to apply to the case, and the court has no hesitation in finding against Scottish ministers where the circumstances justify such a finding. Thank you for your attention.